Hello, IAM siblings. Today I'm here to discuss a recent decision by the United States Supreme Court that sets a new standard when workers request religious accommodations from their employer. For many years, employers were allowed to decline requests when religious accommodations were made, whenever the request would cause more than a de minimis cost. But that's a very low standard, and it let employers lawfully deny most religious accommodation requests. But in a case called Groff versus Joy, issued in June, the Supreme Court changed that standard. That case involved an employee's request not to work on Sundays. In a unanimous decision, the Supreme Court said that that former de minimis standard was too lenient because an employer should only be able to deny a request that causes an undue hardship. The court clearly specified that de minimis would not be sufficient to construe that undue hardship. As a practical matter, the Supreme Court's decision is likely to result in an increase in religious accommodation requests from workers, requests that employers now have to consider more seriously. Such requests may create difficulties for unions because they might pit workers requesting the accommodation against the rights of other workers. Fortunately, the Supreme Court made it clear that employers and unions do not have to agree to override the seniority rights of other employees when considering a religious accommodation request. So we will be able to protect the rights of all represented employees when considering accommodation requests. Shop stewards and other local lodge officials involved in grievance processing need to be aware of the Groff decision, and they should reach out to their business representatives, general chairs, or Grand Lodge representatives if they're presented with difficult issues involving religious accommodation requests, or if they have any questions about the new legal rule.